Good afternoon, everyone. Delighted to have you here with us this afternoon. I'm very much looking forward to presentations today on Northern Ireland, the protocol, and the impact of economic uncertainty. We've got presentations from two governance after Brexit projects. The first is on post-Brexit governance in Northern Ireland. And we'll have a presentation from Dr. Lisa Whitten and Professor David Phinnemore to start with on that. And then we'll move on to a project on the impact of Brexit uncertainties on the economy, in particular on firms in Northern Ireland, with a presentation from Professor Michael Gasiorek. I'll ask a quick question after each of the presentations, and then we'll move on to a wider discussion across the two panels. And members of the audience, I'd encourage you to ask questions on the Slido platform, particularly questions that are directed at the presentations that our two teams are offering today. I'd also say that there's a poll on Slido, a survey at the end, and it'd be very helpful if you could fill that out. It helps us with understanding how to make these events as good as we can. So without any further ado, I'd like to move on to Lisa and David's presentation. And I think we're going to start with Lisa.
I think we're actually starting with me, Dan. Okay, just share some slides. Thanks very much, Dan, for the introduction, and thanks to UK and Changing Europe for hosting this event. Lisa and I want to present on some of the work that we've been doing as part of a project at Queen's. And what we want to do is look at some of the governance challenges that we've identified, others have identified, and how they're being addressed or could potentially be addressed as the implementation of the protocol on Ireland, Northern Ireland, is pursued, and the outworkings of it governments seek to manage. I think there's always plenty that can be said on the protocol. I think it's almost sort of daily things. There are developments. For those of you not aware, there's actually been a court ruling this morning, which is very interesting for the lawfulness of the protocol. Something that we'll be doing some work on in due course as part of the project. I think it just highlights the fact that the implementation of the protocol not only creates a unique set of arrangements for Northern Ireland, and that brings with it governance challenges, but the implementation of the protocol is being pursued in a context where there's a high degree of contestation around the protocol. And that obviously makes for sort of fascinating sets of questions for us to be looking at. Okay, what the project that we're doing looks at is the particular status of Northern Ireland as a place in the UK-EU relationship between the UK and the EU. Northern Ireland is obviously an integral part of the United Kingdom, constitutionally part of it, but under the protocol is placed in a set of arrangements whereby, although it's part of the customs territory of the UK, it de facto operates as if under the Union Customs Code. It's in the internal market of the UK, but obviously has access to the internal market of the EU, at least as far as goods are concerned. Okay, and there are the sets of obligations under the protocol which apply to Northern Ireland, but not the rest of the UK. Now, I think this obviously raises interesting questions about how does this operate? How can the governance for this set of arrangements be effectively implemented in such a way that it does try and address some of the contestation around the protocol? What we also have to remember is that Northern Ireland's position in the UK is unique because of the arrangements which apply in Northern Ireland to Northern Ireland under the 1998 Belfast Good Friday Agreement. And whereas we focus very much as part of the project on the UK-EU relationship, Northern Ireland's position within it, we also have to look at how that fits in with the arrangements for Northern Ireland under the 1998 agreement. So there are multiple dynamics at play here. And as I say, what we're trying to do as part of the project is monitor these and look at the ways in which these governance challenges can potentially be addressed, mindful of the need to try and enhance the legitimacy of the arrangements which are in place for Northern Ireland under the protocol. As part of the work we've been doing, you may have been aware that we've been doing some polling, and I think we published the latest report on this a couple of weeks ago. What's interesting in this from the governance perspective is that although most people see their biggest concern with the protocol being the issue of the maintenance of a supply of medicines into Northern Ireland, the second most important issue which people identified in the poll recently was the lack of voice for Northern Ireland elected representatives and civil society in the governance of the protocol. This, as you see there, was an issue of concern, fair concern or high concern for over 2/3 of those involved in the opinion polling. I think this is fair to say that this has also been reflected in other work we've been doing through stakeholder engagement, which has identified concerns about the question of voice, the concerns about transparency around the protocol, being quite prominent in the minds of people. And this has thankfully at least been picked up on the UK and EU side in some of their discussions about how to continue with the implementation of the protocol. Okay, it's also been reflected in some of the questions that we asked recently in the polling about how people would like to see the views of Northern Ireland voters reflected in the operation of the protocol. And you can see there that nearly 4/5 of people say that there should be formalised structures which would allow business and civil society organisations to input into the work of the UK EU bodies overseeing the protocol. We've asked similar questions before, and there's always been a very strong sense that there needs to be more formalised arrangements for Northern Ireland's voice to be represented. What there's also clearly support for is that there needs to be some sort of parliamentary partnership dimension to the institutional arrangements for the protocol. We see this as being particularly important because in 2024, members of the Northern Ireland Assembly, the MLAs, will get to vote on the continued application of significant sections of the protocol, those relating to the avoidance of a hard border on the island of Ireland. Okay. Just for your information, one of the other concerning features of the opinion polling that we picked up recently is that there's a lack of trust in the print and broadcast media within Northern Ireland to provide balanced coverage of the political and economic developments regarding the protocol. What also should be added to that is high levels of distrust exist around the UK government's position in managing the interests of Northern Ireland under the protocol. And indeed, there's no group within Northern Ireland which actually has, or no group involved in the governance of the protocol, which actually has majority trust in it among voters. The only group that is really trusted on the protocol seems to be business interests. Okay. One other point to just pick up on some of the polling, which has surprised us to a certain extent, is that voters have often claimed that they've got a very good knowledge of the protocol and they have a very good understanding of it. But when we tested this, we actually found considerable proportion of those respondents indicating that or responding inaccurately to a number of true-false statements we put to them. Okay, and so we actually have, in terms of understanding of the protocol, a mismatch between what people think they understand about the protocol and their actual factual knowledge of it. Okay, so what we've been picking up in the project so far is this desire to have voice for Northern Ireland in the process. And what we've been interested to see is the extent to which the arrangements which have been agreed under the protocol for the management of it in the UK-EU relationship can actually adapt to the demands for this idea of greater voice. Before we look into that, I think it's worth just flagging the nature of the government's arrangements that exist. We've probably all come across the UK-EU Joint Committee, which is where over much of 2021, David Frost and Maroš Šefčovič would engage. More recently, Liz Truss, having taken over from David Frost, engaged with Maroš Šefčovič in the European, and the Joint Committee met last month. Beneath that, there is actually a dedicated committee for Ireland, Northern Ireland, which brings together officials, and feeding into it is a set of arrangements and bodies which reflect both the work of both the content of the protocol in terms of UK-EU relations and the application of the evolving EU acquis. So this is the Joint Consultative Working Group, but also bodies established under the 1998 agreement. So the North-South implementation bodies can feed into the work of the Specialised Committee, the North-South Ministerial Council, as well as various human rights and equality bodies for the Article 2 dimensions in particular of the protocol, which relate to individuals' rights. Okay. What's important to note in these arrangements is that because the protocol is part of the withdrawal agreement, it is technically a UK-EU. Each of these are UK-EU arrangements, certainly at the Joint Committee, Specialised Committee, and Joint Consultative Working Group level. There is no facility for direct representation of Northern Ireland, even though the Specialised Committee or the protocol relates entirely to Northern Ireland. That said, within the UK delegation, Northern Ireland is represented, a fact which a fact that is not really widely understood within Northern Ireland, as evidence from our polling also showed. Okay, going back to the question as to whether these arrangements can evolve, I think what has been quite interesting over the last year is the way in which both the UK and the EU has agreed to supplement these arrangements with ad hoc consultations with representatives of business in Northern Ireland, but also representatives of Northern Ireland civil society. Recognition of the need to overcome some of the contestation around the protocol, but also, I think, a reflection of the need to identify the extent to which the issues which people are raising can be addressed through consultation with representatives of business and civil society in these cases. What we've also seen as a novel arrangement is that both Maroš Šefčovič and David Frost have given evidence to a Northern Ireland Assembly committee. Not often do you get national level ministers appearing before a committee of a subnational legislature. You certainly don't normally get a vice president of the European Commission appearing before one. Okay, so the governance arrangements are evolving in response, I think, to this need to ensure that the Northern Ireland interest and voice is heard within the operation of the protocol. Whether that will go further is certainly an issue on the agenda. This is reflected in the fact that the Commission back in October made actually some suggestions as to how you can actually improve the operation of the governance arrangements. So it talked about having a dedicated website on applicable EU law. This is really important in the context of what Lisa is going to be talking about in a moment, the dynamic evolution of the law applicable under the protocol. It also formalized or agreed to formalize these consultations with business representatives and civil society. It also talked about formalized structured dialogue for stakeholders to feed into the Specialised Committee, the Joint Consultative Working Group. It also talked about actual participation of stakeholders at meetings of the Specialised Committee, and also structured groups feeding into the Joint Consultative Working Group. Now, we don't need to go into the detail of this, but what I think is interesting is the way in which you've got a set of formal structures being established to help ensure the implementation of the protocol and manage that implementation. But that is now, it's recognised there are serious shortcomings with that, and these need to be addressed through the enhancement of the framework, through the addition here, particularly of stakeholder engagement. Okay, and then we've also had a commitment recently to at least consider some sort of substructure to the UK-EU Parliamentary Partnership Assembly, so that there can be some engagement of Northern Ireland's MLAs in the governance arrangements for the protocol. Well, whether this will actually solve some of the issues which people have been flagging around governance arrangements, or whether it will reduce some of the contestation, enhance the legitimacy of the protocol, remains to be seen. But certainly in terms of the implementation of the protocol, it is interesting to see the way in which these arrangements are being at least considered for degree of revision or supplementary bodies being added to them, so that they can be seen to work more effectively. Okay. The importance for this is clear because the protocol is a dynamic arrangement. It is also a unique arrangement which places Northern Ireland in a position which many people in Northern Ireland, unionists in particular, feel uncomfortable with. And I think it's a challenge of both the UK and the EU to ensure that these work. What's important to note, though, this is only looks at one part of the consequences of the protocol for the governance of and in Northern Ireland. And that's because under the protocol, there's questions there for the role of the UK, Northern Ireland in the UK, and the extent to which Northern Ireland's voice feeds into the UK position. This is partly a reflection of the fact that there are multiple dimensions to the implementation of the protocol, and multiple complexities which need to be addressed, which I think in certain instances we're only really coming to terms with as we see the outworkings of Brexit and the protocol. Okay, I'm going to hand over to Lisa now. She's going to talk us through some of those complexities and some of the challenges which that raises for the UK and the EU under the protocol. Okay, Lisa.
Thanks, David. You've set up what I'm about to say really well, almost as if we planned it. So the first governance challenge that I want to speak about relates to North-South cooperation on the island of Ireland. One of the stated agreed objectives of the protocol under Article 1, as on this slide, is to maintain the necessary conditions for continued North-South cooperation on the island of Ireland. North-South cooperation on the island of Ireland is the focus of Strand 2 of the 1998 Belfast Good Friday Agreement, under which the North-South Ministerial Council was established to bring together those with executive responsibilities in Northern Ireland and Ireland with the aim of developing consultation, cooperation and action, I'm quoting, within the island of Ireland, including through implementation on an all-island and cross-border basis on matters of mutual interest and within the competence of both administrations. It also set up implementation bodies to help facilitate that North-South cooperation in specific policy areas. And in 1998, 12 areas for potential cooperation were specified in the text of the 1998 agreement, with those new institutions established to allow for future development and kind of growth of that dynamic. During the UK's EU withdrawal negotiation, UK-EU withdrawal negotiations in 2017, UK and EU negotiators jointly carried out a mapping exercise to work out first how North-South cooperation had developed since 1998, and second, the extent to which existing cooperation relied on EU law and policy frameworks that were then shared between the UK and Ireland. That mapping exercise identified 142 areas of existing North-South cooperation, of which 54 were found to be directly underpinned by or linked to EU law or policy frameworks, and a further 42 were found to be partially underpinned by or linked to EU law or policy frameworks, with 46 not being underpinned or linked to. So these findings meant two things. First, that North-South cooperation had expanded significantly since 1998, and second, that in many cases that expansion had been facilitated by or relied on EU frameworks. And this much is reflected in the preamble of the protocol, which recalls the mapping exercise and notes that its findings make clear that UK withdrawal would give rise to substantial challenges to the maintenance and development of North-South cooperation. So why does any of this ancient Brexit history still matter today? Well, because it means that the findings of that mapping exercise act as a really good starting point for assessing the extent to which the protocol achieves its Article 1.3 objective on maintaining the necessary conditions for continued North-South cooperation on the island of Ireland post-Brexit. And using that mapping exercise and the detailed findings that resulted, what you can do is to compare the provisions of the protocol and the lists of EU laws that it makes applicable in Northern Ireland and the provisions of EU law and policy that were identified in that 2017 mapping exercise as the legal policy basis for North-South cooperation in 96 different areas. So that's 142 minus the 46 that weren't directly reliant on EU law. And when you do that comparison, this is what you find. So 35 areas of pre-existing North-South cooperation are fully provided for in the protocol, and through the continued application of those specific EU laws that it provides for in Northern Ireland. 33 areas are partially provided for in the same way, and 28 are not provided for at all. So what this shows us is that, notwithstanding its objective, the protocol, as it currently stands, maintains only some of the necessary conditions for continued North-South cooperation, not all. So this creates a governance challenge because it means that there are gaps, essentially, in legislation and policy frameworks that weren't there before. And as a result, there's decreased legal certainty and increased policy complexity in affected areas. There's no time to go into lots of detail, but for example, in specific examples, but those 28 areas not covered, for example, include North-South cooperation in respect to family and child protection law, North-South cooperation for the mutual recognition of professional qualifications that previously underpinned cross-border delivery of healthcare and education, North-South cooperation related to the management and regulation of water resources, and actually many other areas of environmental policy are included in that those 28 areas, because for obvious geographic reasons, environmental policy lends itself to an area for North-South cooperation. And highlighting this is not to say that North-South cooperation is no longer possible in these and other areas not covered or partially covered by the protocol. It's just that it can no longer happen in the way that it did before, i.e. via EU law. Instead, those 28 areas not covered and 33 areas partially covered by the protocol, to the extent that they continue, must now take place without the supporting architecture of EU law. And to do that, post-Brexit, the operation and development of Strand 2 of the 1998 Agreement and North-South cooperation in policy terms is going to entail navigating a newly complex array of different legislative arenas or spheres that now apply in or are relevant to Northern Ireland, which brings us to the second governance challenge I want to flag, namely legislative complexity. And I might ask for grace from anyone who's seen me present this slide before, including at a recent Research Insights event. But since I'm not going to go all in for an apology, because I think legislative dynamism and complex governance are among the most significant but lesser discussed impacts of Brexit in and for Northern Ireland. And while a degree of complexity is unavoidable in government or governance, and not necessarily negative, if it's unmanaged, then it is a problem because it makes rational policymaking, effective policymaking, much more difficult. And irrational, ineffective policies are much more likely to create confusion among stakeholders and in society, and thus undermine legitimacy and consent for the political institutions of the day. And in the case of Northern Ireland, exacerbate existing issues regarding legitimacy and consent. So that's the context. What does this complexity challenge look like? Well, this slide aims to depict the sources of policy and legislation that continue to be relevant to post-Brexit Northern Ireland, and therefore need to be variously applied and implemented or tracked and monitored, with adjustments made to existing law and policy as need. In the interest of time, again, I'm not going to go through each of these in really great detail, but just to kind of flag the various inputs. You have the 1998 Agreement and related institutions, including the Northern Ireland Assembly and Executive, alongside the North-South dynamic and institutions already mentioned, also the East-West dynamic reflected in the work of the British Irish Council and British Irish Intergovernmental Conference. Linked to the East-West, there's also the bilateral UK-Ireland relationship that includes the unique rights and privileges provided for under the Common Travel Area arrangements. Then we have protocol applicable EU law, the 300 or so instruments of EU law included in the scope of the protocol. We'll come on to in more detail. And those have direct effect in Northern Ireland according to the terms of the protocol and withdrawal agreement, read alongside domestic law that implemented under the 2018 EU Withdrawal Act as amended. And that those protocol applicable EU laws, as I think David indicated, they apply as amended or replaced, which puts Northern Ireland in a position of dynamic regulatory alignment with that selection of EU law, particularly relevant for the free movement of goods. And that's why CJEU case law is also noted, because it applies to the extent that any case law is relevant to those EU law acts that apply under the protocol. Also important to note is the wider UK-EU relationship, as principally set out in the Trade and Cooperation Agreement. And separate but not unrelated, the development of UK trade policy generally through the signing of free trade agreements with non-EU countries is also newly important because of its potential implications across the other spheres. And finally, and most obviously, UK law, which, as the size of the circle indicates and subtitles note, is fluid in the post-Brexit era because of associated changes. For example, the development of the UK's internal market and the common frameworks, regulatory reforms, etc. So hopefully the complexity here is clear. But of course, this isn't the whole picture, because each of these inputs are individually dynamic. And although not always directly interdependent, they're all interrelated in so much as what happens in one sphere has implications for what can, does, or ought to happen in other spheres. Through the work of the project, as David mentioned, we've been doing quite a bit of tracking of developments across these different spheres, and there is movement, which brings us to this final governance challenge on the last slide, which is on alignment and divergence. So as noted, the protocol puts Northern Ireland in position of dynamic regulatory alignment with a specific body of EU law. But what has that meant in policy terms so far? Or to put it another way, how dynamic is dynamic regulatory alignment? Well, as the slide indicates, when the protocol was signed in October 2019, 338 EU law acts applied under its terms and were listed in its annexes. As of the 1st of January 2022, the number of EU law acts has actually decreased to 312 as of that date, and much of that change is the result of the repeal and replacement of relevant EU acts, which serve to mostly or largely to consolidate provisions that were previously made across numerous protocol applicable EU acts into one or two new, more comprehensive EU acts. For example, the Animal Health Law and the Official Controls Act. So notably, and quite important for the issue of alignment and divergence, the majority of these changes that we've seen in protocol applicable law so far were agreed when the UK was still an EU member state. And that's particularly important when we're thinking about managing complexity, because the fact that most of the changes so far arising from Northern Ireland's dynamic alignment were agreed prior to UK exit, also because we haven't yet seen really significant revisions of retained EU law in Great Britain in these areas, it means that the potential likely divergence implications of Northern Ireland's newly complex governing arrangement are largely yet to be seen. Thinking back to the first slide, it's worth underlining that when we consider divergence and policy developments at UK and at EU level, these will have implications not only for relations and arrangements on a Great Britain-Northern Ireland axis that has justifiably been the focus of much of the conversation regarding the protocol so far, but also on that Northern Ireland axis. Just to demonstrate these 2 points, if we look at the Common Frameworks Initiative, which aims to agree frameworks for policy development across the different regions of the UK in the post-Brexit era, where the legislative frameworks, legislative kind of scaffolding of EU law and policy no longer apply. So 19 of 29 what are called Category 2 common frameworks, for which no associated primary active UK law is agreed, overlap to some degree with protocol applicable EU law, and a different 19 of those same 29 Category 2 common frameworks overlap with areas of North-South cooperation as they were identified in the 2017 mapping exercise. So taking a step back and looking at this whole kind of complex governance landscape for post-Brexit Northern Ireland, as it stands, what we have is Northern Ireland situated within and between the regulatory and legislative regimes of both the UK and the EU, including Ireland. And as we move forward in post-Brexit era, there's going to be a correlation between the extent of legislative policy and regulatory divergence between the UK and the EU, and the burden of checks, controls, complexities and bureaucracies that are required in and for Northern Ireland in respect of both the GB-NI frontier and the Ireland-Northern Ireland border. Just to close and reiterate, I don't think complexity is inherently negative, but if it's not managed, it really does make effective governance much more difficult. and is very likely to undermine legitimacy in the architecture of government and politics in any place. And in the fragile political context of Northern Ireland, this task of managing this complex system so as to mitigate the difficulties associated for the formation of rational and effective policy delivery of essentially good government is all the more urgent because of the very fraught and ongoing political debates around the legitimacy or otherwise of Northern Ireland's post-Brexit arrangements. So on that semi-pessimistic note, I'll close. Look forward to questions. Thanks.
Thanks so much, Lisa. Thanks, David, too. Just one quick question before we move on to Michael's presentation. And you've certainly outlined plenty of governance sources of uncertainty for businesses, for firms in Northern Ireland. So there's lots for his project to chew on there. I was wondering, in relation to the evidence you presented about misunderstandings of the protocol in Northern Ireland, whether you have a sense of why the protocol is misunderstood. Now, some of it might be due to the kind of complexity that you've just been talking about. It's hard to get your head around it. On the other hand, it struck me looking at your survey questions that there might be a sense in which people are kind of over-reading the protocol. So sort of assuming that because it's about avoiding a quote unquote hard border, therefore it must preserve all the historic rights of movement that would have been inherent in EU law rather than simply a subset of them. And the other one links to this really interesting question about why, which I'm sure we'll come back to later, but about why there are so few Northern Ireland voices kind of written into the baseline structures for managing the protocol. I don't really want to push at that one yet, but this question of misunderstanding, do you have a sense of why people misunderstand?
I'll go first, Lisa.
I was just going to say, kind of emphasize that we are in a unique scenario where what is ordinarily kind of a niche legal text associated with an international agreement that isn't written for public consumption has become a very central political issue in a place that's quite small, and it has an existing kind of polarized debate. And so that that combination does make it perhaps particularly difficult to get clear information that's uncontested about what is something that isn't designed to be kind of front and center of election posters, which it currently is in Northern Ireland. It's just to underline the unique scenario that we're in. David, do you want to pick up?
I think the one thing to add that is we've always been struck across the 4 polls that 3/4 of people say they've got a good understanding of the protocol. When you test it, they haven't necessarily. I think our working assumption is that a lot of people will take their cues from their political leaders. And here, as we've seen in the post-Brexit environment, political leadership isn't necessarily as honest and as fulsome with its understanding of what the protocol, what the TCA means for the UK, for Northern Ireland. And this then comes back to the question, the issue of it being highly complex and has having to deal with technical issues that would have not been part of political debate before. And I think there's a real serious challenge there of ensuring that there is reliable information available so that people can begin to develop their understanding of the protocols, that we might actually have a slightly more rational and depoliticized debate around it than is currently the case, particularly in Northern Ireland.
Thanks very much. That's really helpful. If I can just encourage people on Slido to start asking questions, that would be great. And at this stage, we'll move on to Michael. Thank you.
Great. Thank you very much, Dan. Let me just share my screen with you.
Great, that's working.
Great, thanks very much. Okay, well, thank you very, very much, Dan and UK Changing Europe, for setting up this event and inviting me to speak. And let me also say that I thoroughly enjoyed the first presentation, and I think it ties in really nicely with the work that we're doing. So my name, by the way, is Michael Gasiorek. I'm an economist, an international trade economist working at the University of Sussex. And I'm currently director of the UK Trade Policy Observatory. So our project is entitled, it's got a long title, as you can see here, Brexit Uncertainty and Northern Ireland Protocol, the Consequences for Northern Ireland Firms and Their Trade within the EU, within the UK's internal market. Excuse me while I cough. Okay, so it kind of, what we're trying to do is what we say on the tin, essentially. So the focus of the project is the following. Following the referendum in 2016, over the course of the subsequent protracted negotiations, and even since there has been agreement, there has been considerable uncertainty for firms in Northern Ireland about the nature of the arrangements they're going to face, both with regard to their economic relations with the rest of the UK, i.e. the GB, and in the island of Ireland, the Republic of Ireland, and with the EU. So there's uncertainty, has been uncertainty over the borders, the barriers, the levels of market access, and uncertainty with regard to, for example, migration rules and requirements. The aim of this research project is to try and unpick and explore the impact of these changing barriers themselves and the uncertainty with regard to those barriers, and how that evolves over time. Lisa used the phrase in her presentation that Northern Ireland is within and between the regulatory and legislative regimes of the EU and the UK. In some sense, that in-between status generates uncertainty, and what we want to do is try and understand what might be the impact of that uncertainty on firms in Northern Ireland. And there are two aspects of the work that we're going to be doing. First, we want to look at firms in NI alone and think about the impact on their sales and purchases. So their sales, firm sales to GB, to Ireland, to the EU, to the rest of the world, and their purchases where they're buying from. And the second part of the project, which we'll be moving on to, and for the moment we haven't yet really started on this part of the work, or we don't have any results to report, is probably more accurate, is to think about what the impact might be of the changing relationship between the UK, Northern Ireland, and EU on firm productivity, in particular in Northern Ireland, but not only, also in the rest of the UK, and in particular arising from the changing composition of the workforce, to do with migration flows, how those changes in migration flows may impact on what firms do, how they do it, and their productivity. The first stage of the work, and I'll be reporting on a few results that we've got, is looking at the impact prior to exit from the EU. In other words, prior to January 2020 or December 2020, January 2021. And subsequently, in later years of the project, a 3-year project, we'll be looking at the impact ex post. Now, you may ask yourselves, why are we looking at prior as opposed to ex post? It's an issue of data. So the latest data that's available at the moment for NI firms' sales is for 2020. So we can look at what might have been the impact on Northern Ireland up until 2019, 2020 for the moment, and as more data comes available, we'll start to look at the ex post impacts. So a key issue underpinning the economic uncertainty for firms concerns the uncertainty with regard to barriers to market access. So prior to the agreement, there was uncertainty as to what barriers might be introduced. These could be tariffs, they could be non-tariff barriers, and along which border, where might those barriers be introduced. And then clearly, since the withdrawal agreement, the Northern Ireland Protocol and the Trade and Cooperation Agreement with the EU, it's more of a question of what barriers have actually been introduced and where, and then thinking about the implications for Northern Ireland, about that ambiguity, that in-betweenness which we heard about in the previous presentation, which stems from Northern Ireland remaining within the EU single market for goods, remaining in the UK's customs territory while applying EU customs legislation, the EU tariffs. So it's a complex set of arrangements for Northern Ireland. If you think about uncertainty, uncertainty is typically closely related to the height of the market access barrier that might occur, that might be imposed. So for a given firm, if there is uncertainty about whether or not there will be tariffs in the future, or how those tariffs will be implemented, or whether or not there will be non-tariff barriers, for example, regulatory barriers arising from GB not being in the single market, then the extent to which that matters to firms will depend on the height of those barriers. If there's a potential that you might face a very high tariff, that's going to matter much more to you as a firm than, well, even if there's a tariff, it's only 1%, well, that might not be such a big deal. Similarly, with regard to non-tariff barriers, what matters to firms, what is likely to matter, is the height of the potential regulatory non-tariff barriers. So uncertainty is closely related to market access barriers. Once the agreement comes into force, once you already know, like we now have the Northern Ireland Protocol, we have the Trading Cooperation Agreement, but we can see there's still a tremendous amount of uncertainty, and that arises from that contestation that we heard about earlier. It also arises because of that in-betweenness and the possibility of future regulatory divergence. So what we're trying to do in this project, what we're aiming to do, is to think about what is the impact of, well, prior to the TCA and the implementation of the Northern Ireland Protocol, what is the impact of uncertainty on NI firms? And then once we get the data, we'll think about the actual impact of both the imposition of these barriers, but also the ongoing uncertainty. So why do regulatory barriers matter? Well, a key principle of the EU single market is the mutual recognition of goods and services. Effectively, what this means is that once a product is placed in the market in one member state, it can be sold in any other member state without barriers. So while the UK was a member of the EU, if you could sell something in London or in Manchester, you could sell it in Paris or Frankfurt. Now, NI for goods has stayed in the EU single market, but GB hasn't. And that's part of that differential status of NI post-Brexit. Remember too that what matters is not just whether there are now different standards across markets, and indeed the standards may not be different. You know, the day after Brexit occurred, or day after, January the 1st, 2021, it's not that the UK suddenly had different standards, but what changed was the arrangements for proving conformity to those standards. So what matters is the fact that there may be differences in standards and regulations across countries, but also what are the rules and requirements for proving conformity to those standards. In the TCA, there is no chapter on the mutual recognition of conformity assessment. The UK wanted this, but it wasn't given. So goods made in GB for sale in the EU must not only conform to EU standards, but they must provide EU paperwork to prove that conformity, and that doesn't apply to Northern Ireland in the same way as it does the rest of the UK. So what we need to do in order to empirically think about what the size of these effects is to measure the barriers. Now, information on tariffs is easy to obtain. Information on regulatory barriers is much harder. Now, as the presentation earlier said, actually very helpfully, the annex to the Northern Ireland Protocol lists all the single market measures that are supposed to apply. And that's dynamic, that does change over time, but it gives us a baseline of all the single market measures. So what we're doing is to use all this information to identify the requirements, provisions, obligations on firms to create an index of regulatory intensity, which we can then apply at the industry product level to think about how firms in different industries might be impacted by those regulatory barriers or the potential regulatory barriers between UK, GB and NI, and the EU. Worth pointing out here, by the way, that's a mandatory standard, which is what a regulation is, might not be a barrier in and of itself. being able to produce to a given standard, for example, being able to prove that you produce to a given standard might actually facilitate market access. But GB firms exporting to EU have to conform to EU regulations and have to prove that they conform. The higher the number of regulations, the more likely it is that that regulatory burden will be higher. That doesn't apply, certainly post-TCA, to NI firms. Prior to the Northern Ireland Protocol, prior to TCA, there was a risk that this might apply, and that's part of that uncertainty. So what do? We go through every single regulation and directive. We use a set of text mining, natural language processing, machine learning techniques to analyze these regulations, and on the back of that, create a number of variations of, and we're exploring the differences between them, of regulatory intensity indices. The simplest is simply to count the number of words, articles, or annexes. Slightly more complicated is to think about the content of those regulations, and that's what we're also doing, where we're focusing on issues to do with what are the standards that are required, what do the regulations say about conformity assessment, and what do the regulations say about how that conformity assessment is surveyed and enforced, with issues of compliance. And then we link that regulatory intensity to products. So here's an example. I'm not going to go through all of this obviously in great detail, but this tells you at the bottom here, I've got a set of 97 industries. That's how trade data is broken down into 90. One way of disaggregating trade data is into 97 industries. And this tells you for each of those broad categories, how many of those single market regulations apply at that level. And you can see sectors such as fishing, machinery, mechanical appliances are the sectors where there appear to be a large number of regulations that apply to firms in those sectors, iron and steel to some extent as well. What you also see is enormous variation across the sectors. So in some sectors, for firms in some sectors, there's a large number of potential regulations that apply. In others, there's a very small number of regulations. Now, of course, there could be just a single regulation, which is very constraining, very binding. So just pure number of regulations is a crude measure, but it's still indicative. This then takes out of those 90 odd industries, the ones that appear to have the most number of regulations, and identifies with regard to the regulations that enforce standards or determine standards to access the EU market, which are the HS chapters which are the most important. And you can see it's fish, it's live animals, it's fats and oils, it's meat and dairy, it's everything to do with food, agriculture, processing, and SPS standards. In the next slide, it's similar to this slide, except that now I'm looking at our measure of regulatory intensity, which focuses uniquely on what the regulations say about conformity assessment and the need to prove that firms produce to given standards. And once again, I've highlighted certain sectors where it appears that that intensity is higher. So again, you've got preparations of meat and fish, you've got explosives, and then at the other end, you've got machinery, mechanical appliances, and electrical machinery. So these appear to be the sectors where potentially regulatory barriers could be higher. Final slide. What we then want to do is to think about what is the impact of those regulatory barriers. So to do this, what we're doing is considering the changes in sales and purchases by Northern Irish firms, and we're comparing the period prior to the referendum with the period after the referendum. So we're looking at what NI firms were selling to GB, to Republic of Ireland, to the EU, to the rest of the world over the period 2014 to 16. And we're seeing how much that changed post-referendum from 2016 to 2019. So in order to do this, we need to use firm level data, which we get from the Department of the Economy in Northern Ireland, and we're using the BASIS data set for those of you who are familiar with Northern Irish data, and we're assessing using statistical techniques, econometric techniques, what is the evidence that there might have been an impact on sales in sectors where regulatory barriers, if they were introduced, are likely to be higher. So in a sense, the question we're asking here is, in sectors where regulatory intensity is higher, do we observe different changes in trade over that time period in comparison to other sectors? And then I've got a very preliminary set of answers for you, but these are very preliminary. It's very early work, like hot off the press. There's lots of checking, lots of fine tuning, lots of refining that we still need to do. With regard to purchases by NI firms, what we find is that even in the post-referendum period, it appears there's a statistically significant negative impact on purchases from Britain by Northern Irish firms, whereas purchases from the Republic of Ireland appear to have gone up. Where we focus on that measure of conformity assessment, if you recall, that was a variant of this measure here in this slide here, then purchases by NI firms from Republic of Ireland and the EU also appear to go up in comparison to purchases from GB. So already, even before the Northern Ireland Protocol, before the implementation of the TCA, there appears to be a sort of an effect on where NI firms are buying their goods from. Interestingly, with regard to sales, where they're selling, for the moment, there are no statistically significant effects. So this is preliminary, and I've focused on only a part of this project. So at the moment, I focus very much on this impact of regulatory barriers. And we spent quite a lot of time in trying to think through these regulatory barriers, because interestingly, you might think after all, the single market, the EU single market has been around for a long time, but actually there is no index of regulatory intensity for the single market. Nobody has put something like this together before. And in a sense, the annex to the Northern Ireland Protocol provides a very neat way of trying to do that, precisely because it lists all those measures that matter, and then that gives us a way of building this index of regulatory intensity and then linking this to products and then thinking through what the impacts might be. So let me stop there. Thank you.
Thanks so much, Michael. That was fascinating. I know you said your results are very much preliminary. Would it be over-interpreting them to suggest that firms in Northern Ireland were effectively anticipating the likely impact of the protocol and the TCA and adjusting their purchasing behavior in anticipation of future but as yet unknown regulatory burdens?
So let me give my cautious answer first, which is that almost any interpretation of the results at the moment is over-interpreting them because they're preliminary. But your explanation is perfectly reasonable. But if you are a firm and you're anticipating higher barriers, then you are likely to adjust your behavior now, depending on how big you think those barriers might be. So the fact that we seem to be finding positive evidence that where those barriers are higher or appear to be higher, I should put that differently. Where the regulatory intensity index is larger, it does appear to be the case that there's more adjustment by firms in terms of where they're purchasing from. But as I said a minute ago, interestingly, not at this stage with regard to sales.
Do you have a kind of an instinct or a hunch or a hypothesis about why the difference between purchases and sales exists? Why there's, in effect, there seems to be no effect on sales, at least so far?
No, not currently. I mean, it might be that on sales, it's more the tariffs that play a part. So one of the things we also need to look at simultaneously is both the regulatory barriers and the tariff barriers, and we need to do that simultaneously, which today we haven't yet done. It's kind of the next phase. And I also think we've only got data up until 2019, which is fairly early. We're about to get the next data set up until 2020. So I think the story is going to get a lot richer. And then we'll be able to unpick it a little bit more by sector to really work out what's happening across different sectors and think about what the story is and what the explanation is.
Thanks. Can I invite David and Lisa to turn your cameras on again? And I wanted to kick off our discussion just by reflecting on the remarkable complexity of these governance arrangements, and to throw in a bit more complexity, in the sense that the UK-wide arrangements, as refracted through the protocol for Northern Ireland, but the UK-wide arrangements around the Internal Market Act and the operation of the Internal Market Act, around the common frameworks that Lisa discussed in such an interesting way. I mean, all of that seems to me to add in additional complexity and not yet to be kind of settled down. It hasn't yet kind of sedimented into a set of arrangements that it's easy to describe or to set out in full the kind of standard operating modes. I know that in Wales, for example, there's currently a certain amount of anxiety amongst officials about what to do about the labeling of free-range eggs in the light of the concerns about avian flu, and whether changes to that labeling might fall foul of UK internal market regulations and constitute a sort of internal barrier. So the level of complexity that you were describing and analysing, Lisa, seems to me to be even higher, simply when you think about the UK's internal governance, economic regulation arrangements, and I wondered how much that level had filtered through into the debate in Northern Ireland. I imagine nowhere in the UK, is it what people are talking about in the cafes and pubs. But in terms of the sort of policy maker discussion, do you find kind of concerns about common frameworks in the internal market?
Thanks. Yeah, I mean, I would agree with you entirely in many ways that actually, although as complex as it is already, at the minute, it is less complex than it will be because of the process that we went through in terms of transposing all of the EU law that applied to the whole of the UK, and we haven't really seen substantive change in that yet. And all of the new structures in the Internal Market Act and the common frameworks, they're all yet to be tested to any very significant degree. Has common frameworks filtered down? It hasn't been front and centre in the political debates, but there is awareness in the Northern Ireland Assembly and certain committees that the circumstances have changed and that there is going to have to be additional monitoring, and so the awareness of it in principle and the relevance is there, but in terms of digging down into the substance of what this means for individual policy areas, we haven't seen a development of the conversation along those lines yet, in part because and you would have to acknowledge that the discussion of the protocol in the Assembly and in Northern Ireland politics generally is very divided, and it is focused on in principle arguments largely. I think as time goes on, the policy impacts and implications will naturally come more to the fore as they're kind of realised on the ground. And there are lots of different examples that you could flag in terms of how they are coming through or might come through. But we haven't seen it kind of progress yet very far in that direction. And the lack of the executive and all of the tensions around that and the elections make all of that harder. So it's, yeah, not sure if the others want to comment on that. But.
Just one thing to add. We talk about complexity. We've got contestation. I think it's the lack of certainty around so many other issues that we've still not got within the wider UK the structures in place to necessarily manage the likes of the common frameworks, but also then the interaction between all these different spheres that Lisa highlighted. Because in some respects, there seems to be something, well, the Northern Ireland's got the protocol. Okay, but no one's really sat down and thought, like, how does that interact with all these other dimensions? And whether that's something which needs to be pursued within the UK, or whether that needs to be done in the UK-EU relationship, and what the respective competences and responsibilities are there.
Let me just add two things to that, and I agree with what's been said there. Two slightly different things. The first is that I don't think we do yet have a clear understanding of how the UK internal market is going to work and how those common frameworks are going to work in practice. And that increases the complexity both within the UK internal market clearly, but also in relationship to third countries. And what happens if we sign up to certain provisions in a free trade agreement, which are actually the scope of the individual devolved administrations to legislate with regard to, and how does that get managed and so on. The second point I would make in terms of the actual how this will impact on firms and ultimately therefore people is we're at the very, very early stages. Clearly it is highly complex. Firms tend not to like complexity, they tend not to like uncertainty. This is going to impact in different ways on investment flows. And it's hard to know, in particular, I think, for Northern Ireland, what those impacts will be in the direction of the impact. And clearly it'll vary a little bit by sector and by firm type. So on the one hand, it might be that there is, in inverted commas, a Brexit dividend that, as is sometimes said, that Northern Ireland has the best of both worlds. It's got better access to the EU market and better access to GB. It's got better access to the EU market than GB. It's got better access to GB market than the EU. There may be benefits from that. And I think there clearly will be for some firms, some sectors. But equally, we're raising barriers in various dimensions, and that's not so good for firms. And related to that too might be the ability to take on and hire workers from abroad as well. The second thing I would say, the third thing I would say, I said I was going to say two things, I said third thing. Third thing I would say is, again, in terms of the impacts, which is one would expect, and this is part of what we hope to be looking at, that these impacts, you know, as I said a minute ago, firms don't like complexity. It's particularly hard for SMEs, small and medium-sized enterprises, to deal with complexity. So the bigger firms, the big distributors, big producers will probably manage this transition much better than much smaller firms.
And presumably that has spatially, it has different impacts in different places, because the mix of larger and smaller firms will be different, and the relative footprint of SMEs in the Northern Irish economy is going to be larger than it would be, for example, in the economy of the southeast of England. That's really fascinating. I'm struck actually hearing you, Michael, talk about your index of regulatory intensity and the work that David and Lisa and colleagues are doing in terms of, tracking the regulatory and governance environment in Northern Ireland. I know UK and a Changing Europe is also doing a kind of regulatory divergence tracker related to the TCA in general. I'm just struck by the huge volume of new work that needs to be done in terms of working out how to track these things, how to measure them, and then actually going on and measuring them over time. And it fascinates me that, it seems to be academics that are doing this work predominantly. I'd be interested to know whether you've got a sense of any of the governments involved, the Northern Ireland Executive, the UK government, or indeed any devolved governments, are doing this kind of regulatory tracking work, or whether this is a sort of public good or a good for governments that we as academics are now having to provide. Do you have a sense that there's an appetite for your work, or that governments are doing this kind of thing in a different way?
I don't know of any government departments that are actually doing this sort of work, and I work quite closely with DIT, BEIS, and Department of Economy Northern Ireland. I don't think they are doing this sort of work, to my knowledge. But I think there's a lot of interest in what we're doing. Every time I mention this work about regulatory intensity and trying to measure it and trying to think about the impact, then I get a lot of positive feedback saying, when you're ready to publish this work, when you're ready to talk about it more, and in some sense, this is almost the work's first outing, then I've seen a lot of interest from policymakers and more widely on seeing this work and working with this data.
I think we'd see from our perspective a lot of interest in the issue of regulatory alignment with the EU and the way in which that is evolving. And we know from some work on the operation of this joint consultative working group, the extent to which there's a regular exchange now of detail between the EU and the UK about what changes need to be coming about. And Lisa can say a little bit more on just the extent of the change. But going back to the point I initially made, I think a lot of the issues we're raising about the complexity and how you manage that, not just in the UK-EU context, but within the internal UK context, is not something which has necessarily been picked up. And that's partly because there are so many different dynamics which leaving the EU has unleashed within the UK, so many different agendas there and issues to be addressed. I don't think you've necessarily had people, particularly at the time of COVID, when so much capacity has been diverted elsewhere, really dedicating the time to thinking through how do you manage this within the UK context. But I also think there's a more institutional issue there is, and you may appreciate this, Dan, from Cardiff, is I think Brexit has taught the UK that it probably doesn't necessarily know enough about how the UK operates, or it thinks it operates or should operate, than possibly was the assumption. That the realities of having devolution have been highlighted by leaving the EU and the shared regulatory context which that provided, not just for the UK vis-a-vis other EU member states at the time, but also for the component elements of the UK.
Yeah, I would just add to that, agree with everything that's been said. Just to maybe flag that in conversations with officials and governments and those involved in managing it, tracking is going on and there is a lot of interest in what we're doing. But I guess the nature of the arrangements, and because we are in a new era and it's unprecedented, I do think it's the case that no one government team or department and no body is looking at the whole picture. So in Northern Ireland, there are those that are looking specifically at Northern Ireland areas of policy and the extent to which changes in EU law, kind of how they trickle down there. But there's also, of course, a kind of indirect importance in tracking GB developments and that divergence issue. You do find some tracking divergence, but in a narrow section of their policy responsibility within a given UK government department, looking at how it interacts with the protocol, but not thinking through how it might interact north-south cooperation or how it might sit in relation to the TCA and trade policy. And again, it comes back to this, we're in a new context, and things like flagging the development of post-Brexit UK trade policy and its relevance for Northern Ireland because of the nature of the protocol and the arrangements under the 1998 agreement, and bilaterally UK, Ireland, and all of the regulatory aspects that Michael has so articulately outlined, means that what is a reserved competence towards the UK government very clearly is now of policy level, kind of day-to-day life, potentially relevant on the ground in Northern Ireland. That's a whole new capacity that's going to be required amongst officials to track. But where does that sit in the governance setup that we have? And there hasn't therefore been like a kind of overarching strategy and or therefore delegation of responsibility to look at the big picture. Although you do see little kind of sparks, which it lends itself to academia, but I would also suggest it's not a long-term strategy for us to track all of the developments.
Let me add to that, and I agree very much with what Lisa just said, is that many of these aspects of retained EU law, the way it's been done is that much of this can be amended by ministers introducing secondary legislation as opposed to through primary legislation, which makes it much easier for ministers to change the rules, for example, over chlorinated chicken or whatever, as opposed to it being voted through in Parliament. And so there's much less scrutiny and discussion as to what those changes in retained EU law might be going forward.
Just quickly on that, sorry, I could keep you here from now until next week going through examples of where changes in secondary legislation have direct or indirect protocol implications, and how much variation there is in the tracking that or acknowledging that in explanatory memoranda and stuff. And overall, I mean, it's fluid, and yeah, there's more management required.
Thanks. That's really fascinating. I mean, one of the things that strikes me about the drivers, the dynamics behind a lot of these changes, is that the UK government has opted for and pushed through a form of Brexit that makes sense if your aim over the medium to long term, is to try and take advantage of kind of new freedoms, of an ability to diverge. So there's an underlying logic of that sort that then pushes out the implications of divergence or the possibility of divergence through the wider governance system. I mean, picking up on something that David said about the pandemic, about COVID, I was struck actually, perhaps in a slightly different direction, by the urgency with which the UK government pushed the UK internal market legislation through, actually in the midst of the pandemic, and where, as I read the situation, especially given that the regulatory regimes of the devolved governments were all in alignment with EU rules, so there wasn't, it seemed to me, therefore, an immediate urgency about a kind of threat of significant divergence. And in that context, and I know this is an area of Michael's very strong interest in the new Centre on Inclusive Trade Policy, but in that context, the logic seemed to me to be a logic that was more related to the ability of the UK government then to go ahead and negotiate trade deals with other parts of the world, kind of knowing that it had controlled the risk of divergence through devolution, at least in part through the internal market legislation, and there does seem to be a sense that that the UK government is very keen to achieve new trade deals, but perhaps rather less of a sense that there is a systematically thought through kind of trade policy orientation that animates all of those different deals that the UK government has been trying to make. Do you think that's an unfair characterization, Michael, or?
No, I think that's a pretty fair characterization. I think at the risk of oversimplification, it seems to me that UK non-EU trade policy, I guess what we used to call external trade policy, is very much focused on, let's show that we can sign free trade agreements, that there is a global Britain out there, and that we can lead the way on signing modern, we lead the way on everything at the moment, don't we? We can lead the way on what constitutes a modern free trade agreement. And that's very much, that I think, the focus of politicians, because it demonstrates, I think they believe it serves to demonstrate the value of having left the EU. And as you point out, Dan, I think there is insufficient attention being given to quite what we want from the chapters within those agreements, for example, with regard to regulatory equivalence or SPS or TBT. I mean, it's notable, for example, that in the two recent agreements that, in a sense, the only new free trade agreements that the UK has signed, the one with New Zealand and the one with Australia, where regulations we know they matter the most in trade between countries is to do with SPS measures, sanitary and phytosanitary measures, which apply to sort of food, agricultural products, processed food, and so on. And in both those new free trade agreements, those chapters are not subject to dispute settlement. So there's not much by way of agreement, not much by way of regulatory equivalence, although there's sort of some talk moving in that direction, or cooperation in that direction, but actually there's very little on dispute settlement in those agreements. So there are areas where I think the UK government has, across a wide range of areas in these free trade agreements, I don't think the UK government necessarily has a clear objective that this is where we want to be with regard to SPS, this is where we want to be with regard to digital trade, this is where we want to be with regard to services or mutual recognition of professional qualifications in X years' time. It's, let's just see what we can negotiate with each free trade partner as and when we face them at the negotiating table in order to be able to get a deal.
Thanks. Did anyone else want to come in on that?
I think just a quick observation. I think for those people who follow the protocol, they identified very early on that it actually put constraints on the extent to which Northern Ireland would be able to benefit to the same extent as the rest of the UK in any trade agreements which the UK did sign with beyond the EU. I think when we look at the terms of the agreements, there's normally just general clauses in there, essentially saying that the trade arrangements for Northern Ireland will be contingent on the extent to which the obligations exist under the protocol. I think what you're finding is that there's no real sense as to what that interaction, what the restrictions will be in the UK, in the position which the UK has adopted in going into these negotiations. The priority, as I think Michael has indicated, was to conclude the agreements, and it's one of the issues which now needs to be addressed, is to what extent do they interact with the protocol, and does the protocol act as a constraint on the extent to which NI businesses can access those agreements. Thanks, David.
I have some questions for Michael on the Slido, and the main one is from Bart and asking at the end of your work, would you be able to predict which possible divergence, e.g. which sectors in GB would most impact in Northern Ireland? There are also some other questions you might be able to pick up around the fringes of that, about the exact timeframes of the two aspects of the work. And someone's asked whether purchases refer to firm inputs.
So I'm taking notes here. Okay. Predict, I think, is hard to say. I think what we, in terms of that first question, I think what we would be able to do, what we hope to be able to is to identify both which sectors are most likely, appear to have been affected the most. And you could therefore think about that, saying, well, if in the future there was changes, these are the sectors that may be impacted most, but also which aspects of standards. Is it to do with the standards themselves? Is it to do with conformity assessment? Is it to do with compliance? What is it that might be impacting most on those trade flows? So, for example, that early evidence that we've got, and I repeat, it's preliminary, appears to suggest that NI firms' purchases, what they're buying, is increasing where the conformity assessment measures were highest. So that suggests that conformity assessment might be playing an important role there. So we'll be able to unpick that in more detail. Timeframes, essentially what we want to do is to divide up our time sort of pre-actual Brexit and post-actual Brexit. There is a question mark as to, the post-Brexit, does one go after January 2020 or December 2020, January 2021? And I think it'd be better to do the latter because that's when the TCA actually kicked in. But obviously that means that we have to wait until we can get that data, which is usually a couple of years later. In terms of firms' purchases, yes, these are the inputs that firms are buying. Now, to the extent, if you're a producing firm, you're a manufacturing firm, then that will be the inputs that you're buying. If you're a distributor, then it might be that you're buying something for resale.
Thanks. That's very helpful. David and maybe Lisa, I wanted to go back to something that you talked about, David, in your part of the presentation, which was effectively about the very limited, in fact, pretty much absent place of Northern Ireland representatives in the in the kind of formal high-level arrangements governing the protocol, and I wondered, you were talking about that in terms of this being an agreement concluded between the UK government and the EU. There was a bit of experience of representatives of devolved ministers working on the Council of Ministers in areas of devolved policy competence and so on. So I can sort of see that there would be a kind of logic of not having devolved representatives directly involved on a agreement between a state and the EU. But I wonder if there's more to the story than that. I mean, was it ever considered, do you know, having more devolved representation? And it does seem that that's growing up kind of organically to some extent from other parts of the presentation.
I think that there's two dimensions to this. The first is at the high levels of the Joint Committee, the Specialised Committee, where the UK and the EU come together. I don't think it was ever going to be the case that you'd actually specify the nature of the UK delegation in the treaty between the UK and the EU. It's ultimately going to be up to the UK government to determine who is going to be part of its delegation. And what we saw with the New Decade, New Approach, the agreement which brought back the executive in Northern Ireland, was a commitment on the UK government to ensure, essentially where the Irish were represented as part of the EU delegation, that there would be a representation from the Northern Ireland executive attending meetings of the Joint Committee or the Specialised Committee. And that did seem to be quite an odd arrangement to make presence of Northern Ireland ministers or officials contingent on the presence of Irish officials on the EU side. But I think the general principle is in the UK government that, okay, well, where the UK is attending the Joint Committee, which is dealing with the protocol, then there will be representation from Northern Ireland. That then raises the question as to what the nature of that representation is and what role it can actually play. The understanding is that the officials and ministers from Northern Ireland that attend are simply there in an observer capacity. I think what's going to be really interesting as part of our work is to actually look at what sort of involvement they do actually have in these meetings. And moreover, what sort of role do they have in the formulation of the UK government's position for presentation at those meetings? So in other words, are they simply invited after the position of the UK government has been identified and it's almost a sort of symbolic presence, or is there substantive engagement on the development of the UK government's position to be presented there? And also then, what role can they actually play as observers? Are they active observers in the process? So, and I think that might be dependent on this whole debate about the need for the Northern Ireland voice to be fed more directly into the process. I think just the other dimension to look at is the extent to which particular arrangements were going to be put in place to recognise the fact that this is the protocol on Ireland, Northern Ireland, and therefore a protocol which needs to be implemented in the context of the '98 agreement. And when you do look down at sort of the substructure to the governance framework, it is interesting that the North-South Ministerial Council, which when it operates, can make recommendations to the Specialised Committee. There are references elsewhere in the protocol to these institutions established by the '98 agreement, but it's never been fleshed out. And if we're thinking about developing arrangements which may enhance the legitimacy of the protocol, I think there's work to be done to see the way in which you can use these other bodies where Northern Ireland is represented in terms of what they contribute to the governance of the protocol and its institutional framework. We're at early stages in that, and there's obviously politics around that as well. Insofar as in order for the NSMC, North South Ministerial Council, to be making a contribution, you need a functioning executive in Northern Ireland. Okay, so there's potentials here. And I'd say looking at it from an EU external relations perspective, it is interesting the way in which you've got bodies here which are not EU third country bodies, but bodies established by another arrangement, the '98 agreement in this case, feeding into the institutional structure which has been established in this agreement between the UK and the EU.
That's really fascinating. Just to press on as it were, the big P and small p politics of this. You've been emphasising how kind of caught up in contentious politics in Northern Ireland the arrangements around the protocol have been, and how that kind of shapes public understanding even of the protocol. At the same time, there's this point about Northern Ireland voice, and I know from some of your other work that you found that businesses and business organizations are actually amongst the most trusted voices on these issues across the public in Northern Ireland. So in one sense, it would seem that would seem a good avenue. You also talked about civil society organizations, and so organized civil society in Northern Ireland, is diverse, and some parts of it are very much about kind of getting beyond the community divide, and other bits are deeply rooted in the communities. I'm just interested in the challenges around bringing voices from, as it were, both the traditionally identified communities, but also from other voices into these governance arrangements. Are there challenges for organized civil society in that respect?
Can I just throw in an additional question?
Carry on. Very good.
I was also intrigued by your survey results suggesting the distrust of what the media is presenting. Now, you might think that that's how many people get their information. So how does one build that? What is the role of the media in what Dan is asking? And why is the media so distrusted, the output from the media?
Okay. I think, do you want to come in on that one, Lisa, or the media question?
You go ahead. I might supplement.
This is the first time we've actually asked the media question in what is a relatively small poll in terms of the number of questions we can ask, and I think it is a question we want to look at further. It came about because of the concerns that we were picking, or the discrepancy, as I mentioned earlier, that we were picking up between those who claim to have a very good knowledge, but low levels of trust in the UK government, and this sense again that they did think the reliable information was available, but weren't necessarily answering questions about factual understanding about the protocol, which revealed a level of understanding contingent with what an accurate level of understanding of the protocol. So I think that's more work to be done on that. I think going back to Dan's point about engagement with civil society, I think there's a history of in Northern Ireland of a struggle to get civil society's voice identified in a structured manner. One of the failings of the post-98 agreement period has been the absence of the civil society forum, which was anticipated at the time. I think that the reason why we've seen business representatives particularly trusted in this particular context and the engagement with them is because I think both the UK government and the EU wanted to understand what the practical implications were of seeking to implement the protocol. What were the challenges? And there was a concerted effort, I think, on both sides to engage, both individually and then directly. But it was also, I think, a response to the extent to which business has successfully organised in the post-Brexit environment to identify challenges as well as opportunities that Brexit would throw up in the context of having particular arrangements for Northern Ireland. I think what we need to remember in this process is that very early on, the trade implications or the implications for business of a potential hard border on the island of Ireland were being identified by business. And once that fed into the idea of having particular arrangements for Northern Ireland which avoided a hard border, business people began to identify, well, if the UK has the hard Brexit, which we didn't know about, we didn't know the detail of until the end of 2020, then what would be the implications for East-West? And so I think you began to have a far more developed discussion within Northern Ireland and then issues being raised. I think also the fact that those businesses were often coming with factual problems, actual real problems, as opposed to politicized issues, enabled them to have a degree of access which wouldn't necessarily be the case for those pursuing particular political agendas around the protocol. The question now is, if you move away from more informal structures around early implementation of the protocol into arrangements which are more structured and possibly about the future of the protocol, there are then questions about the extent to which the business representatives are generally representative of the entire business community in Northern Ireland. And if you've got civil society representatives, are they generally representative of civil society in Northern Ireland? So there's questions of selection there coming through. Big challenge, I think.
Thank you. Did you want to come in, Lisa?
Just briefly, and I guess echoing on the point around concerns about the media and quality of information and misinformation and who to trust. I think it's interesting when we run these surveys, we generally receive very high number of comments submitted in a kind of optional comments box. So about 20% of respondents every time have inputted often really detailed perspectives on Brexit, the protocol, and the situation in Northern Ireland. So we've done coding of those comments, about 500-600 each time. And just to say generally, there is a clear growing concern and attitude that is generally very critical of politics in Northern Ireland and political institutions in Northern Ireland and the political debate. And I think there is a risk of a growing discrepancy between the focus of Northern Ireland politics and the focus and concerns of Northern Ireland society. And I would say that in that respect, Northern Ireland is not unique in the UK context or in much more widely in the Western political context of today in terms of populism and concerns around news and quality of information out there. But because of the particular history and unique power sharing government setup that we have here, there are kind of unique pressure points and potential trajectories that could happen there, and a widening between the kind of policy level day-to-day concerns of society and the political conversation and the ability of institutions to manage division and policy complexity and requirements there. So I think it's a dynamic in contemporary Northern Ireland that is one ripe for research and that needs to be considered more.
Thank you. We've actually run a little over time, so thank you to the audience and also to the presenters for bearing with us. I'd just like to wrap up with a big thank you to our three presenters, to Lisa, David, and Michael. We're facing, I think, some really deep and challenging governance and economic questions in Northern Ireland, but across the UK as well, as Lisa was suggesting at the end there. And it's a real privilege for me to listen to such thoughtful, rich, and sophisticated analyses of what is a critically important set of issues in Northern Ireland, but for the UK as a whole, for Europe more generally. So thank you three very much indeed. And I look forward to working with you more in the future.
Thank you for the invitation.
Yes, thank you. Pleasure to be here.
Thanks, Dan.